Our agenda tells us that the next speaker is Mr. Professor Davor Derencinovic from University of Zagreb. Mr. Professor, the floor is yours. Good luck.
Thank you very much. Can you hear me?
Yes, I hear you. I hear
Perfect.
you, Professor.
Perfect. Thank you very much. So, ladies and gentlemen, dear colleagues, good morning. I'm very grateful to both Institute of Justice of Cardinal Wyszynski University in Warsaw and Ferenc Mádl Institute for Comparative Law from Budapest, and to both directors, Professor Vielec and Professor Szilágyi, for their continuous, not only for the event we are witnessing today, but for the continuous support on this really excellent project. And I'm really very privileged to be a part of it. And I think that it shows very clearly that the scholars who live and work in Middle Europe and the Southern Europe are not just the passive side, I would say, just the consumers of what's being produced in the West, but also those capable of contributing to the debate of the general interest. And this is the social media, freedom of expression, and legal regulation of various harmful contents, including the fake news. So according to some estimates, in 2019, slightly more than 50% of all the people in the world had access to internet, while in 2009, this number was very, very low, around 5%. In Croatia, in 2019, almost 80% of citizens used the internet. And for comparison, 40% of them used the internet back in 1999. And I think that is very similar comparisons apply to social media as well. And the problem is that this exponential growth of users has not been coupled with increased media literacy, knowledge about the risks of victimization of global networks, and public awareness about harmful content. Legal regulation of internet and social networks is a problem that has come under attention recently and raises so many relevant questions. First of all, what are the side effects of the freedom of expression on the internet? How to protect those who are the most vulnerable from harmful content and abuse? Who stands behind creating and disseminating harmful content and fake news? Foreign governments, terrorist organizations, private sector, or someone else? What is the purpose of generating harmful content and fake news? Creating panic and confusion, maximizing profit in the spirit of the new pattern of surveillance capitalism, controlling certain target groups of users, or something else? And out of many issues relevant for this topic that I deal very in depth in my paper that will be published soon in a scientific monograph, due to the time limit, I will try to focus on just one that seems to be very interesting and conceptually very complex. And the previous speakers touched upon this issue, and that is, what is the nature and the scope of content provider responsibility for the user-generated content? And this is very topical now for Croatia because of some recent legislative reforms that are taking place in the country. There is a new draft Electronic Media Act, and probably the most important novelty brought by DIMA is Article 93, paragraph 3, which states that a provider of an electronic publication is responsible for all content published on an electronic publication, including the content generated by users. And this provision, as you can imagine, has caused the most doubts and different interpretations of its meaning, scope, the way of its enforcement in the future, and so on and so forth. First of all, as you can imagine, there have been concerns that extending service providers' responsibilities to user-generated content would call into question their normal functioning. Namely, especially when it comes to the web portals with many followers, it will be very difficult to expect that editors will be able to follow all the comments, and if necessary, filter those with inappropriate and banned content. Several factual and legal questions also rise here. First of all, according to the draft provision, will service providers be obliged to verify the veracity of a certain content? And will they have to determine whether certain content is, for example, incitement to violence or hatred or fake news? The legal basis for attribution of responsibility for acts of another over which the content provider has limited possibility of supervision is also quite disputable. from the strictly legal and criminal law point of view. This solution is also questionable when it comes to the standard of personal culpability. Namely, the mentioned criminal offenses are without exception punishable only when they are committed with intent, which means that a perpetrator either seeks to achieve a prohibited consequence, for instance, incitement to discrimination or hate speech or similar, or at least agrees to it. It's dolus eventualis in criminal law. So the perpetrator is indifferent towards the consequence. On the other hand, when it comes to a content provider, his liability may be based on an omission in which there are no elements of intent, but possibly negligence. This raises several doubts about how to attribute the publisher's responsibility for user-generated content while maintaining the principle of guilt intact. There have been concerns that this could result in terminating the possibility in general to make comments online. Given that the possibility to make and publish comments attract many readers, some electronic media fear that by abolishing the possibility of commenting, their portals may become less interesting to the public. But this is, of course, just one side of the coin. On another side, there is no doubt that electronic publications, at least some of them, generate revenue on the market, not only for the content offered to the public, but also for content generated by users. This is the logic of advertisement and paid ads. The principle is the more clicks on certain links, including comments, the higher the advertising revenue for the content provider. If this generates revenue, in other words, if it is a matter of monetization of activities on a given portal, then there is no reason whatsoever why the same media should not be considered responsible for anonymous comments helping them generating extra profits. So as always, we have here the issue of the balancing. This is a very delicate issue of competing rights and interests, and that's what lies in the heart of our constitutions and in the heart of Article 10 of the European Convention on Human Rights. And I think that interpretation of this provision, not only in my country, in a future legislation, but also in other countries, would depend not only on the circumstances of the given case, but also on the standards on the responsibility of electronic media for content generated by users that's been established in the jurisprudence of the European Court on Human Rights. And there have been 3 very relevant cases decided by the Strasbourg Court concerning intermediary liability of internet content providers. The first very interesting and very important case was Delphi versus Estonia. Delphi is an online news portal that publishes more than 300 new news items a day, and it allowed a possibility of comments from readers generated automatically immediately after they were written without additional editing or deletion by the portal. In this particular case, at the beginning of 2006, in addition to an article relating to the enterprise, to the company, there were many comments, around 200 of them. They were very, very defamatory, and they also consisted some elements of the hate speech towards the director of the company. And his lawyers requested the removal of those comments with a claim of around 30,000 euro for non-pecuniary compensation. The disputed content was removed, but not immediately after 6 weeks after the publication, but the portal refused to pay the compensation. In domestic proceedings, the Internet portal was declared liable under the provisions of the Civil Obligations Act for publishing offensive value judgments, insulting another person's honor, and failing to remove such content on its own initiative. The European Court, though, found that the impunged comments constituted hate speech, which did not enjoy protection under Article 10 of the Convention. Also, according to the court, the Delphi portal is a professional internet portal with news that, for commercial reasons, tries to attract as many comments as possible, even when it comes to the neutral topics. And given that it was quite obvious that there was an economic interest of the portal for as many comments as possible, the European Court concluded that the portal didn't have the function of a mere passive technical service provider. The portal's filtering measures were clearly, according to the court, not sufficient protection against speech that was openly in a function of spreading hatred towards the director of the given company. And the European Court found the same concerning removing comments over a long period of time and on someone else's initiative. Ultimately, the European Court found with two separate and dissenting opinions that there had been no violation of Article 10 in the present case. Though there were two other cases, one concerning Hungary and one concerning Sweden, in which court did not find the violation of Article 10 due to the reasons that the impunged statements on the web portals were not considered as a hate speech. It is quite debatable, especially in the Hungarian case, but it was the position taken by the court. And in Appeal versus Sweden, a case where the court declared the application inadmissible as being manifestly unfounded because the major reason for that was that the applicant claiming defamatory online comment sued the non-profit organization on whose website the comment was published. So in brief, what are the lessons learned from the ACHR jurisprudence on this topic? These cases indicate what should be taken into account by national legislators and domestic judicial and regulatory authorities with regard to the issue of responsibility of electronic media for user-generated content. There is a clear message from the Strasbourg Court, although, as I said, we can debate, we can discuss some of the finding of the court. And these messages, the provision on the responsibility of media should not be used as a carte blanche for holding them liable for just any offensive and inappropriate content generated by users. This would, I think we can all agree on that, no doubt result in some sort of sui generis censorship that would run contrary to the principles of the free speech. On the other hand, the mere theoretical possibility of holding internet media responsible for the violation without its adequate enforcement would be interpreted as a wrong signal of the regulators that everything is allowed for the profit. Therefore, in my opinion, sound and fair decision-making should take into account balancing of competing interests. In this regard, the following issues should be kept in mind by those in charge of decision-making. First, content of the statement. So it's a zero tolerance to hate speech, but first, we have to be quite clear on what really constitutes hate speech. Profile on electronic media, small and non-profit versus large and profit-oriented corporations. Preventive measures taken by the media, for instance, filtering harmful content, hate speech, incited to terrorism, and so on, and the promptness of the reaction of the media in taking down the disputed content. To sum up, some commentators suggest that countering harmful content online, including fake news, through user-generated content, does not make any sense in a world where the truth has already gone. They're deeply convinced that we already live in a matrix of a post-truth world. The term has been used to describe an environment where common standards of humanity agreed upon through the layers of history first faded out and then just vanished. For those more moderate, the modern world seems to be trapped in a crisis of truth, some sort of epistemological limbo. They suggest that ubiquitous postmodernism relativized most of the historical narratives, and some modern, as we know, as we witness, some modern collective ideologies or movements serve the same purpose. The first victim of their aggressive imposing of the new narratives, including through social media, is freedom of expression, which is on the verge of being altered with what? With an empty shell of political correctness, which is basically nothing. The truth is always somewhere in between. It was a rhetorical question, it still has not gone, but it has indeed been under multiple attacks. The cannons are fired not only by those already mentioned, but also by profit-oriented corporations, non-democratic governments, totalitarian regimes, totalitarian ideologies, aggressive non-state actors, terrorist and anarchist cells, and many others. The central arena where this global warfare is taking place is cyberspace. The result, unfortunate result, is the physical world polarized by emotions instead of harmonized by reason, and divided through street spectacles instead of united through democratic institutions. So how do we get back onto the right track? I think that the answer lies in the root causes of the problem itself. The truth has to be revitalized, protected, reinforced. And it's absolutely crucial because this post-truth world will be the place of no values, no truth, no values. The world without values will distort the concepts of the modern societies we're built upon: democracy, human rights, human dignity, and the rule of law. In more practical terms, defending the truth means defending what we agreed upon through the layers of history. There's this minimal consensus. And that's why the Europe, the place we live in, is the best place for living in the world. And defending truth means defending the Constitution as a generic term, as an expression of will and consensus about the most fundamental values shared by free citizens in a democratic societies governed by the rule of law. The most crucial on this quest is to keep the rational approach, preferring soft law alternatives. As we heard from Professor Vielec, I cannot agree more. Criminal law is ultima ratio. Do not use criminal law to tackle every single issue that might seem as the offensive on the internet. Building partnerships, investing in education as a barrier to indoctrination. That is probably the most common method of the aforementioned anti-truth and anti-democratic initiatives and alliances. And having this in mind, I think that over-criminalization and over-regulation of internet and social networks does not seem to be a model that would work out in the long term. Namely, while it is undeniable that fake news and other harmful content have negative potential and is serious threat to the democratic societies, the idea that this phenomenon should be suppressed at all costs is perhaps even more dangerous. Democratic societies are based on the freedom of expression. Who has to decide? I think courts and other decision-making bodies, not self-regulation, not the media itself, that's for sure, because they're interested party. They cannot decide who has a right to access and who doesn't have a right to access. And I think that a widespread campaign advocating various forms of repressive action against fake news would be deeply wrong and harmful for the very core of the democracy. And to conclude, yes, it does make perfect sense to counter fake news and other harmful content as a phenomenon that harms society. The same goes for all the other forms of harmful content, hate speech, hatred, incitement to hatred, incitement to terrorism, and so on. And I would say no, this is still not the world where the truth has gone. Sometimes it's under pressure, it's hiding, it remains silent, but this is, I think, just temporarily. The truth will find a way, because it always does, just like water, because I think we can all agree it would be impossible to imagine life without either. So I'll stop here and looking forward to your comments and questions. Thank you for your attention.